We're still waiting for one presenter, but what I'm going to propose to do is that we begin this session. And I'm going to begin by introducing our panelists. And the panelist we're waiting for is Justice Colin Campbell, and he may have been held up for a time in court. So let me proceed, if I can, to introduce one of our first panelists, Ms. Chantal Proulx, who's here on behalf of the Office of the Commissioner for Review Tribunals, which is the independent body that does review tribunal hearings on claims under the Canada Pension Plan. Now, Ms. Proulx has worked with this office for some time. She practices mostly in the area of administrative law with a focus on Canada Pension Plan and old age security issues. She's had a number of experience working with the plan in terms of policy and otherwise, and her own practice as well over the time in terms of conducting various training and programs for staff and panel members, and brings a considerable amount of expertise in the area of the Canada Pension Plan, its criteria, and the procedures applied by panels to deal with those matters. Ms. Sophie Martel is here as well, and she is here as a vice chair of the Workplace Safety and Insurance Appeals Tribunal. And Ms. Martel has, since the call of her bar in 1995, worked with the WSIAT in different capacities. From 1995 to 99, she was a lawyer with the Tribunal Counsel Office. She handled a significant caseload, particularly of complex appeals, including occupational diseases. In October 99, she was appointed as a vice chair of the Tribunal, and she is currently serving in that capacity. And I would note as well, I learned that she is also bilingual. The next representative we have here to my far left is Mr. Fred Sampliner. Fred has been an arbitrator with the Financial Services Commission of Ontario since 1993. He graduated from a U.S. school initially and has come to Canada and been working significantly in the areas of civil litigation and personal injury, initially through his work with Sampliner, and later Sampliner and Finley. And when he came to Canada, was admitted by the Law Society and has then, as I said, taken on the role as an arbitrator at FISCO and has served in that capacity. So we're happy to have him here to give us the perspective again of an adjudicator of the accident benefit type claims. And again, the last of our speakers will be Justice Campbell, who will join us shortly. So perhaps if we could begin then, and perhaps we might start with Chantal.
Good afternoon. Just a heads up, the paper wasn't available in time to be put in your binder, so if you want a copy of the slides, you can find that on the table as well. So, as was mentioned, I'm bringing with you today the experience and expertise from counsel for the Office of the Commissioner. So I'm not an adjudicator per se, so you'll get different expertise from my other two colleagues and from the Justice. But basically what we're dealing with is we have panel members across the country who hear these cases. At our peak, we hit about 11,000 cases across the country, and right now we're leveling off at about 5,000. So who's the Office of the Commissioner? Well, we hear appeals for the Canada Pension Plan as well as the old age security. In the context of today's conference, the Canada Pension Plan is more relevant because this is where we find the definition of disability. So just to situate where we sit, under the Canada Pension Plan appeal process, there's an initial decision by the department. It's now Social Development Canada. A person who's not satisfied with that decision has 90 days to ask for the department to reconsider their own decision. And this is where we come in after the second decision by the department. It's now the Office of the Commissioner who's set up to hear the appeals, and it's going to be heard by a review tribunal. And after us, there's the Pension Appeals Board. So as you can see, it's a pretty lengthy process for people, and they're rarely in this process without being either with workers' compensation or with the long-term disability or something else. So it does get very confusing for the appellants that come before us as to what is the test? Is it a similar test to what I've been dealing with? How is it similar? How is it different? And I have to say it gets very confusing for them. So who are the panel members who decide? Well, the tribunal is composed of 3 people that are chosen by our commissioner. And at this time, our commissioner has passed away, so it's now our deputy commissioner that's acting in his place, for your information. The panel is up to a maximum of 400. Presently, we have about 270 panel members across the country. They're all part-time appointments, which you can see the juggle, how it could be a little difficult to handle the 5,000 cases when you have people sitting across the country, on average 3 days a week, 3 days a month, sorry. So we usually sit on Tuesday, Wednesday, and Thursday. So it can be a bit of a challenge. And you can see there might be a bit of discrepancy in the outcomes when you're dealing with a national program versus a provincial program. And keep in mind that only the tribunal can hear and decide the outcomes. There's nobody within the office that has any decision-making power. So sometimes it's a little confusing. We'll have people call in or write and say, well, can you change the outcome of the tribunal's decision? No, that can only be done at the Pension Appeals Board level and not ours. So on all panel where we're dealing with disability, that's about 95% of our work is disability appeals. So there always has to be a legal member, and that will be the chairperson. They're usually responsible for writing the reasons in the decision. Then there's always a medical member sitting on the board and a general member, always comprised of 3 people. We don't have the choice between 1 and 3. So how does someone qualify for a disability pension? What's different from a lot of the other things we've heard this morning and this afternoon is that Canada Pension Plan is a contributory plan. So unless you've made contributions to the plan, you can't qualify for a disability benefit even though you may be disabled. So it's for people who have been in the workforce and have paid their contributions to the Canada Pension Plan. And then the second part, they have to meet the definition of disability. So how do you effectively present your case before the review tribunal? I don't know how many of you have experience or have been there. I know that the majority of our appellants are not represented, or if they are represented, it's usually a family member or a friend. So there's very few people who actually have the legal training that represent clients before the tribunal, which is a little too bad because obviously there's a lot of experience in the room and they could definitely benefit from it. It's obviously a cost issue to some degree. So first thing to know before you can present a case, you have to know the legislation. All the pieces of legislation are slightly different, so know and understand the terminology. The first criteria for disability, you're going to find it at paragraph 42.2a. So basically, the person has to be considered to be disabled if they're determined in prescribed manner to have a severe and prolonged mental and physical disability. So the Act and the regulation does tell us what prescribed manner means, and then severe and prolonged are also further defined. A disability is severe only if by reason thereof that the person in respect to whom the determination is made is incapable regularly of pursuing any substantially gainful occupation. I have to tell you that when you start doing the training for panel members, they often associate the medical condition with being severe. Well, is a heart attack or a heart condition severe versus chronic pain? And you say that's not the test. Severe is not is the condition severe, it's in what is your capacity to work. So we have to be very careful that people understand it's related to capacity and not, for example, finding work or not to the medical condition itself. So the test of severe was, I guess, explained a lot better in the Villani case. So if you do come before the review tribunal, I would recommend that you look it up. We have a link on our website to Villani. They basically expanded on the definition of severe. The federal court said, you know, you have to give meaning to each and every word in the definition. There's a reason it's there. So it's not, can they do some type of job? It's not, can they do work on certain days? It's, are they incapable regularly? And regularly has a meaning of pursuing any. So it's not your own job simply, it's any other job that you might be suited for. And again, it has to be gainful. So what is the definition gainful? It depends on case by case. The Quebec pension plan is a little easier in the sense that they've actually put an amount on gainful. What they've done is said 12 times the maximum monthly pension for disability, that's what is considered to be gainful. You don't have that guidance with the Canada pension plan. However, you might want to use that as a guide. The other thing that you have to keep in mind with Villani, it's called the real world approach. Is it reasonable for a person who's 59 years old who's working in construction to go back to school and be a computer engineer? Probably not. So put it in the context of that person, and you can serve your client very well if you do that. The second part of the test, and then keep in mind they have to meet both, so it has to be severe and prolonged, not just one of the two. So to be prolonged, the disability has to be, and again, in prescribed manner, it has to be likely to be long continued and indefinite duration or likely to result in death. So the cases that are likely to result in death don't usually make it to our level at the review tribunal. You're usually dealing with cases that are indefinite duration and likely to continue. So again, chronic pain, chronic fatigue, are they going to last? Most likely. It's rare that you see somebody said that they've been sick for really 6 months, that kind of stuff, because by the time they get to our level, you're probably looking at 1.5 to 2 years. And the other thing I would refer you to prepare the case is look at what prescribed manner means. Basically, the Regulation 68 says that they want the report of any physical or mental impairment. They want to deal with the nature, the extent, and the prognosis. So it's easier if you have that kind of information to bring to the doctor or put in a letter and say, this is the kind of information that the tribunal is going to be looking for. Again, they want to know the findings upon which the diagnosis and prognosis were made. What are the limitations from the impairment? Again, some of the functional evaluations that have been talked about, a lot of it will come out from those reports. And again, any other relevant information. Another thing that's a bit different than maybe in some other scenarios is they want the person's occupation and earnings. We have something called a record of earning. Everybody has one that's made contributions to the Canada Pension Plan, and that document is usually provided by the Department of Social Development. And that will list all the years with the amount of your earnings. And that way you can determine whether or not someone made sufficient valid contributions in each year in order to qualify. It's also a very good tool for the panel members to examine somebody's work history. Have they been very sporadic, or have they continued to work all these years and all of a sudden they become sick and it's really the same date that they claimed they became sick, and then you start getting the corroborating evidence. Again, person's education, employment experience, and activities of daily life. This goes back to the capacity to work. It goes back to the real life. Is it likely for somebody that doesn't have a lot of work experience to go back and do something else? Has it always been the same work for 25 years? Or have they done 10 different jobs and they've been able to adapt? So something else that the panel members are going to look at. Another thing, review cases. Now, each case is going to be based on its own merits. And the Pension Appeals Board, which is the next level, does have a lot of case law available to you. Those are not binding on the tribunal. However, they can give you some guidance as to how the tribunal may look at things or how to prepare your arguments. Another good recommendation, submit your information ahead of time. When you get to the review tribunal level, it's unlikely that they're going to say, well, we'll just recess and come back. If they can't hear the evidence, and if you present too much evidence at the hearing, chances are it will result in an adjournment. The case may not be heard for another 4 to 6 months, which is a detriment to the client trying to get a benefit. Knowing the hearing file very well, the panel members will have read it, but in order for you to present what's critical, you'll have to be able to get to the elements that show the person can't work. Why can't they work? What have they tried? What have they done? What is their treatment? Are they following? All that kind of stuff will be interesting and important to point them to. And again, we talked about credibly being very critical. Same thing here. The oral presentation from the appellant is very important. At the other two levels, it was a paper hearing, so a decision was made without even meeting the appellant, where on this case, it's their first chance to come before people and actually explain their story, tell them what happened, usually a very good indication for the appellant. Burden of proof lies on the appellant. There's that misconception sometimes that, well, the government must have access to medical reports, therefore they should prepare and get it in front of the tribunal. The tribunal does not obtain the documents. We simply present the documents that have been sent to us and we give it to all the parties as well as the decision makers. So it's important to understand that it is up to the parties to present the documents. And the standard balance of probabilities. You know, it's not beyond a reasonable doubt, not the same burden, but you still have to make your case. So here's the consideration for all disability claims, and I'll just touch upon the ones that are a bit more important for chronic pain, chronic fatigue, and fibromyalgia. First thing you need to do, calculate the minimum qualifying period. For those of you who don't practice in that area, it's probably going to be very daunting the first time. Give us a call at the office. There's 4 lawyers on staff that would be glad to help you out through the calculation. Basically, you need 4 years of valid contribution within a 6-year period if you're applying now. So if people have never paid into the plan, it'll be very difficult for them to qualify. So we don't even get to the second step of whether or not you're disabled if you haven't paid contributions to the plan. So you would first look at the record of earning, determine if they qualify, and if they do, what is the last date? Because that calculation determines the last date a person can be found disabled. So for example, if your last date is 1999 based on your contributions, but you have a terrible car accident that stops you from working in 2000, you'd be out of luck. You can have all the medical evidence to prove you're disabled as of that date, but if you're not disabled within that time frame, you don't qualify for a benefit. So a bit of a different rules. Again, they'll look at definition of severe and prolonged that we've talked about, medical evidence that's on the hearing file. If you bring something at the hearing, they'll consider the exhibits, and obviously the oral testimony. So this applies to all claims. What are some of the other considerations that have been mentioned in the decisions from the Pension Appeals Board and from our panel members in their decision when you're looking at some of these conditions? Well, first of all, it's not sufficient for the condition to exist. I think we've mentioned that enough today. Some people have the condition and they can still work, while others are affected differently and they can't work. So the real issue is the pain has to prevent them from regularly pursuing substantially gainful occupation. That's still your test. You're back to the test of severe, and it's not whether do you have chronic pain, or do you have fibro, or do you have a heart condition. You know, bottom line is you could have no condition, the doctor could have no idea of what you have, but if people can tell you that there's no capacity to work because of the following reasons, you could technically qualify. And there's even been some decisions that say, well, we're going to find somebody disabled prior to the diagnosis because it just wasn't available. Technology wasn't there, we didn't figure it out, or they were misdiagnosed, and that happens. So just keep that in mind. We don't necessarily need a label or condition, and that doesn't tell you or dictate the results. Treatment was sought. It will be looked on as a negative impact if the person never sought the treatment. Now, there are some situations where the person could not follow treatment. For example, they didn't have money to follow it. There was no experts in the area. You guys might not see this as much in Toronto, but I can tell you in the more remote areas, that's what comes up with the appellant's testimony. Say, well, there's nobody in the area, or I was not told to do this, or I was not referred to that person. Creates a different dilemma. But if treatment was sought, then they want to know what the results were. Another element that's important for the panel members to consider is the efforts to cope with the pain. Have you done something? Have you tried the physio? Have you tried to work? Have you gone back to work part-time? Have you tried a different kind of work? So they're going to look at that kind of information. So if you're representing a client, make sure that everything they've done is noted and is explained to the tribunal. Another thing that's interesting is treatment is not followed. It's fine as long as there's a reasonableness for the non-compliance. For example, in some cases of dangerous surgeries, you can explain that away and it won't have a negative impact. If you've tried certain types of treatment in the past and they have not been successful, that might also help the client explain why they didn't follow certain treatment. A very interesting one is attempt to work. What have they done? And we heard about duty to accommodate earlier today. Well, did the employer go on and take on that responsibility? Did they try it? What was done? How did they modify the duties? Are they capable of doing that, or just lighter work? Again, credibility, case-by-case basis. I mean, it's just very difficult when you don't have the objective medical findings, but I'd like to point out in the Canada Pension Plan, it also never mentions the need for objective medical evidence. So be very careful when somebody says, well, it's not going to be successful because there's no objective medical evidence. We see this sometimes in the minister's submissions. It's still the wrong test. There is no requirement for objective. So somebody can win the case simply on the subjective. But again, credibility will come into play. So you will want to see, is there a family member, or their friends, or their coworkers that can come and support how they were before and how they are now? Is the employer available? Sometimes we have an employer questionnaire that's going to explain why they're no longer able to work, what has been done, all the attempts. So that's very interesting and can definitely help with the credibility issue. And keep in mind, credibility is a case by case. I mean, it's going to depend on who the client is, and the more informed they are about what they are there to do and to represent their day-to-day and how they actually live and how the case or their condition is impact on their daily life will be very useful. And then some of the cases have said, well, although it's not necessary, in cases of chronic pain and chronic fatigue and fibro, evidence of psychiatric, psychological, or physiatric nature is really desirable. It's a good tool to help the panel members make a decision as to what is really going on with this person. Are they capable of working or not? Are they malingering? What is the issue with the pain? And again, lastly for me, work history. We have the record of earning, where have they worked all their life? It's unlikely somebody making $60,000 a year for 25 years is just going to decide, well, today I don't feel like it, today I'm all of a sudden sick. You know, it's human nature. Most people do want to work and be productive, and I'm not going to say that there is no fraud, and we haven't seen cases where people are pushing the envelope a bit, but I have to say the majority of the cases we see, there's something going on. So whether they qualify for the definition of disability and whether or not they've made enough contribution is a different issue, but they're rarely very well. So we are dealing with a clientele of about 5,000 appeals this year, and none of them are in great shape. So it's a challenging situation for them, and I think we have to do the best we can to help them. And if there's anything that we can do in our office to give you information or that you can give clients in order to prepare for the case, and if you're not representing them, don't hesitate to give us a call. We're not there to represent any side. We're just there to make sure there's a fair hearing, fair procedures for everybody. Thanks.
Thank you, Chantal. Thank you. Our next speaker then is Ms. Sophie Martel from the Workplace Safety and Insurance Appeals Tribunal.
Thank you. Today I'm going to talk about three things, just give you some background information about the tribunal. Secondly, about how we adjudicate chronic pain, disability, and fibromyalgia appeals. And thirdly, give you my personal experience as a vice chair hearing and deciding these cases. So briefly speaking, the Workplace Safety and Insurance Appeals Tribunal, which some of you will know as the Workers' Compensation Appeals Tribunal, is the final level of appeal in matters of workplace safety and insurance for workers and employers. The tribunal hears and decides appeals from final decisions of the board, and we are separate and independent from the board. Those of you who are not familiar with our work in workers' compensation law might be surprised to find out that there is a large body of jurisprudence about chronic pain, disability, and fibromyalgia, although I can't say the same about chronic fatigue syndrome. Another thing you may wish to keep in mind if you do not practice in this area of law and have no desire to practice in this area of law is that the Workplace Safety and Insurance Act removes the right of action for work-related injuries in many cases. And you may wish to ascertain if your client suffered her injury in the course of her employment at the outset of a potential lawsuit, rather than after you have racked up large legal fees only to be brought before the tribunal and find out that your client does not in fact have the right to sue. And believe me, it's happened. Since the tribunal is the last level of appeal for work-related injuries, this means that the board, the first level of decision-making, has previously often completed a substantive investigation regarding the claim. The tribunal and all participating parties in the tribunal appeal get what we call the board file. This file will include the board's investigation, medical reports from both treating physicians and independent assessments, as well as the opinion of the board's own medical advisors, and finally, the board's decision. So as a result of having this board file, we at the tribunal are less dependent on what the representatives may choose to bring forward to us. That is not to say that representatives cannot submit their own medical brief, but just that this medical brief will be reviewed along with all of the other medical opinions found in the board file. The fact that we have all this additional information is especially important in the context of single-party appeals, which is a frequent occurrence at the tribunal, since employers do not always participate in worker appeals. The tribunal itself has investigative powers and may seek additional medical opinions from treating physicians or from its own roster of health professionals. This will usually be done at panel or vice chair direction, usually after one hearing day has been completed and before submissions have begun. With respect to chronic pain disability appeals, well, in Ontario, the Ontario board recognizes chronic pain disability and treats chronic pain the same way they treat any other workplace injury or illness. In other words, there are no limits on benefits compared to other disabilities, provided that the entitlement criteria are met. And I mention this because the Nova Scotia legislation and regulations excluded chronic pain from the purview of the regular workers' compensation system and provided, in lieu of benefits normally available, a 4-week functional restoration program beyond which no further benefits were available. And the Supreme Court of Canada recently struck down these provisions in their entirety because they infringed Section 15 of the Charter and were not saved by Section 1. And that's the Nova Scotia Workers' Compensation Board and Martin. And I believe it was mentioned in Brenda Bowlby's paper as well. This Supreme Court of Canada decision merits a conference topic in of itself, but I do want to quote Mr. Justice Gontiier's opening remarks in the decision, and this is paragraph 1 of his reasons. Chronic pain syndrome and related medical conditions have emerged in recent years as one of the most difficult problems facing workers' compensation schemes in Canada and around the world. There is no authoritative definition of chronic pain. It is, however, generally considered to be pain that persists beyond the normal healing time for the underlying injury or is disproportionate to such injury and whose existence is not supported by objective findings at the site of the injury under current medical techniques. Despite this lack of objective findings, there is no doubt that chronic pain patients are suffering and in distress and that the disability they experience is real. And then he goes on to explain about possible explanations for this and says, despite this reality, since chronic pain sufferers are impaired by a condition that cannot be supported by objective findings, they have been subjected to persistent suspicions of malingering on the part of employers, compensation officials, and even physicians. So this fairly strong language to start out a decision, and if you're looking for legal recognition of chronic pain, there it is. In Ontario, chronic pain disability is recognized with no limit on duration or level of benefits, as I said earlier, but you do have to meet the entitlement criteria, and these are outlined in the board's policy on chronic pain disability, which you'll find in your materials. And just going through the criteria briefly, first of all, a work-related injury occurred, so there has to be some initiating accident that occurred at work. Secondly, the chronic pain must be caused by the injury. So in looking at this criterion, the policy stipulates that there must be evidence of continuous, consistent, and genuine pain since the time of the injury and a medical opinion that the characteristics of the pain are compatible with the injury. As many of the criteria for obtaining chronic pain disability entitlement are subjective and the reported pain is inconsistent with the organic findings, tribunal decisions have held that the panel or vice chair must have special confidence in the worker's testimony that his or her pain has been continuous, consistent, and genuine. The third criterion is that the pain persists 6 or more months beyond the usual healing time of the injury. Fourthly, the degree of pain is inconsistent with organic findings. And fifthly, the chronic pain impairs earning capacity. And here there must be evidence that demonstrates the persistent effects of the chronic pain in terms of marked life disruption. And we're looking at the effects of not only work, but also activities of daily living, physical and psychological functioning, as well as family and social relationships. Workers diagnosed with fibromyalgia are considered for compensation benefits under the same policy, the chronic pain disability policy. My own personal view in adjudicating these cases is that they are difficult, and for this reason, I find the policy a useful tool in terms of focusing the evidence and submissions on whether the 5 criteria of the board's policy are met. So representatives for the worker or the employer should therefore address these criteria in their evidence and submissions rather than general statements about why someone is or is not deserving of benefits. In terms of evidence that I like to see the family doctor's clinical notes and records for at least 2 years prior to the injury. If submitting a psychiatric report, I'd like to see a discussion in the report about any pre-existing or coexisting non-work-related factors that may be playing a part in the disability, just because without it, one is sort of left wondering as to what has been omitted, if anything. Medical reports. If you're going to submit medical reports from treating practitioners, avoid the advocacy type or inflammatory reports that just go on and on about how awful their patient was treated by the Workers' Compensation Board, well, the Workplace Safety and Insurance Board, and just stick to what doctors know best, and that is the history of the symptoms, the diagnosis, the level of disability, and what their views on the etiology may be. If the doctor is going to give an opinion on a worker's ability to do their job, it would be helpful that the doctor knew what job it is the worker is being asked to do, and not just simply from what the patient is telling the doctor, but also what the employer may have forwarded in terms of physical demands analysis or a job description. Sometimes by the time an appeal comes at the tribunal, the medical reports found in the board file are outdated, and it is helpful to get an updated report as to what's happening currently in the patient's medical condition. With respect to video surveillance, it's actually rare in our hearings to see it, and there are certainly difficulties because they tend to depict a certain moment in time, and there are all kinds of explanations as to why it wasn't necessarily a reflection of the ongoing nature of the disability. So I don't think the appeal is going to be won or lost on the surveillance, but maybe in the context of all of the other evidence it may be helpful. So if yes, you've got medical reports suggesting malingering or secondary gain, you've got inconsistent statements, and a failure to even attempt a return to work, then perhaps the surveillance is going to help. But in of itself, it's really not going to make or break the appeal. And thank you.
Well, thank you very much. Our next speaker then is Mr. Fred Sampliner with the Financial Services Commission of Ontario.
Well, let me just give you a brief overview of the Financial Services Commission. It's a regulatory arm of the Ontario government. And within that is the Dispute Resolution Group, for those of you who don't know. And it's composed of arbitrators and mediators. There's about 40 mediators, and there's 17 arbitrators. The 17 arbitrators were all experienced lawyers, and we travel the province conducting hearings under the Insurance Act. And within that, we're always hearing lots of cases about chronic pain. I've been a member since 1993, since I joined the commission. And our jurisdiction is basically to handle accident benefits. We decide claims for benefits under the no-fault portion of your insurance policy. And for those unfamiliar with those benefits, the schedule as we call it, it provides people with weekly disability benefits, housekeeping assistance, medical and rehabilitation expenses, and other benefits. We do not adjudicate tort claims, which is for the courts. But the arbitrators are familiar with tort concepts, structured settlements, and valuation, because we often discuss both aspects of injury claims during settlement discussions at the Commission. The number of claims in arbitration has risen fairly consistently during my tenure at FSCO. We still are able to offer very fast service to get these claims to a hearing, which is oftentimes very important for clients. Pre-hearing dates occur 4 to 6 weeks after an initiating application, and 4 to 6 months after the pre-hearing, you'll get a hearing. So that's quick service. We schedule these pre-hearings at FSCO's North York office for GTA residents, and by teleconference for people outside the GTA. Currently, FSCO is studying the feasibility of regularly offering face-to-face pre-hearings outside the GTA. And it's important to remember that we can arrange face-to-face pre-hearings currently outside of the GTA on special requests where the circumstances warrant. The pre-hearing serves two purposes. Basically, it's to set the stage for the hearing, but primarily we try to focus on settlement. So we'll go through the issues that are in dispute, we'll discuss them, we'll talk about the exchanges of documents and make any orders that are needed. If there's preliminary issues to decide or motions, we'll handle them or set them up for another hearing. But we'll set the date for the hearing. But primarily we try to see if we can settle the claims at the pre-hearing. So there's a great deal of focus on that. The face-to-face pre-hearings offer the best opportunity to realistically assess the strengths and weaknesses of a chronic pain case head-on. At that point, the arbitrators uniformly find that the best results occur when the parties do their homework ahead of time by exchanging the documents before the pre-hearing or getting most of the information exchanged before the pre-hearing. They also feel that you get the best bang for your buck at the pre-hearing by having both parties present. Sometimes lawyers will want to shield their clients by not having them present, but especially for a chronic pain case, the personal attendance of the parties is an imperative. Personal attendance is even outlined in FSCO's practice notes, and the Dispute Resolution Practice Code sets out the Commission's guidelines for pre-hearings, hearings, and the conduct of the proceedings, all of which are available online at our website, along with all of the case law, and that's all free of charge. What I've found in my experience is that people suffering chronic pain seem to need an informal opportunity to explain to an insurance company what's going on in their lives ahead of the hearing. A hearing is a very formal process. People are oftentimes scared. They are under the gun, as we all know. And it seems as if they need this opportunity to explain their side of the story, and also for an insurance company to explain their problems with accepting the case as well. I would say if you want to resolve a case at a pre-hearing, I honestly think that you need the insured person there and you need the insurance company. So before you get to a pre-hearing at the Commission, or I would say in a pre-trial or any place, you've got to talk to the client about your strategy, the alternatives, and realistically assess the expectations of the client and yourself, and talk about the figures, how that translates out. Oftentimes what I'll find is at a pre-hearing is the parties are totally unprepared for either to talk about settlement, and the client and the lawyer oftentimes are not on the same wavelength. That really interferes because each of the people is outside of the other one's experience and expectations at that part, and it may take them days before they come to the realization, by which time the settlement opportunity has gone. It's always a good idea to prepare a case summary. That puts your mind into focus for the evidence, and I think that's very important to do before the pre-hearing so that you can also assess the evidence and line it up as well for yourself and your client. In addition to pre-hearings, the Commission also conducts settlement conferences, motions, and of course the arbitrators conduct the hearings, but we also offer non-binding opinions, what's called neutral evaluation. This is another opportunity for a person suffering chronic pain to have the option of going to a place where it's a little less formal and unfriendly. A neutral evaluation is an abbreviated process where the parties can present their document briefs and they can make submissions to the arbitrator and then have a discussion about the results of that. And the technique is shown to have a very high success rate, and if you fail, you can go on to the hearing and have your shot at that. Now, if you can't settle the claims at any of these processes that we've offered, the case law does offer some guidance as to what FSCO's arbitrators look for in chronic pain cases. As has been discussed by other panelists, it's not necessary to engage in a debate about whether the person suffers chronic pain, chronic fatigue, or fibromyalgia. Arbitrators don't need to determine a particular diagnosis. We employ instead a functional approach, focusing on the severity of the pain from the accident and its effect on the insured person's abilities. Pain in itself is not compensable, but the disability resulting from the pain is. And the initial test for the weekly disability benefit is whether they suffer a substantial inability to perform their essential tasks of their job. We need fairly detailed evidence about the job tasks. Oftentimes, people fail in providing that, either through an occupational therapist, an agreed statement of facts, or the an employer's statement about what the job tasks are. The insured persons, they may have some pre-existing problems, whether they're psychological or physical, but these aren't necessarily a barrier to the benefits themselves. The insured persons must show that the accident is a material or a significant contributing factor to their disability based on chronic pain. Towards this, the experts need to fully and logically explain in their reports the basis for their treatment recommendations and the precise and balanced reasoning behind their opinions on disability. Make sure that the expert addresses the specific test. Oftentimes, an expert will put together a beautiful report and then just completely fail to address the specific test. If they don't do it in the report, have them prepare an addendum that does address that and fully and logically explain it. They should also explain any inconsistencies in the person's behavior, observations, surveillance, work returns, and interpret their clinical notes and records. That's oftentimes a problem in deciphering doctors' records. We encourage people to file reports and not call expert witnesses. If you call an expert and the expert testifies beyond the four corners of their report, that's not necessarily a no-no. They can testify beyond what they've stated in their report. Don't have them repeat the report, because we don't need to simply have somebody sit there on the witness stand and read the report. But we also need to have the other side put on notice of any substantial changes in the nature of the opinion that the doctor has given, so that there's no surprise to either side. The arbitrators look for persuasive evidence, compelling or persuasive evidence on recommended treatment of chronic pain to demonstrate it's reasonable and necessary, and that's the entitlement test for treatment. Perhaps this isn't a scientific certainty in chronic pain, but we need more than a simple, bold assertion. Pain relief being a legitimate goal at the Commission, it needs independent corroboration. And towards that, I think what we want to have is some corroborative evidence through friends, and I think this has been reiterated by one of the past panels. We need corroborative evidence through friends, neighbors, relatives, spouses, co-workers, health practitioners, of what the ongoing problems are. That can be, some of the most compelling evidence can come from the co-workers and people who've had dealings with them on a day-to-day basis. Family practitioners are very important, who've oftentimes seen these people on a weekly or bi-weekly basis. The insured person needs to provide us with an adequate explanation of why they can't perform the job tasks with some specificity. And if there are inconsistencies with their self-portrayal, they need to explain that on the stand. We don't need to have gaps. We don't like to have gaps in the evidence where we don't quite understand why the person has sat there through 2 days of testimony and hasn't explained why they were observed doing this, or why this person has failed to explain either surveillance or observations by other third parties. We need to have a consistency of the complaints and the disability with the healthcare providers, and attendance and compliance with appropriate treatment. If there is presence of supporting objective findings and test results, we'd like to have those highlighted. And especially, we need to know a little bit more about the changes in the person's pre-accident and post-accident lifestyle. That's been highlighted in the previous panel. I think that's very important to present a day in the life before and a day in the life afterwards, so that we have a very good idea of how things have gone for that person. We have a small part of the Insurance Act called, that's people refer to as a special award. And I'll just mention this in passing, is that Section 282.10 of the Insurance Act provides that an insured person can recover more than what the benefits they're entitled to, if they can show that the insurance company has unreasonably delayed or withheld benefits. Now, that test is a lower test than for punitive damages, meaning that you don't have to show outrageous conduct or egregious conduct. Basically, it has to be an unreasonable withholding or delay in benefits. There's limitation on the amount that can be awarded, but I just alert you that sometimes what people will simply plead this in, well, we don't have formal pleadings, but they'll claim this amount as a special award, and then they'll subsequently at the hearing fail to offer us evidence. We need to have evidence directly, not just from an adjuster about what they've done, but about what constitutes exactly the unreasonable delay or withholding of benefits, so that we can make a decision based on that claim. That's all.
Thank you very much, Mr. Sampliner. That's very helpful. Our final speaker of the day is the Honorable Mr. Justice Colin Campbell, and he's joined us. And just before we get to him, I'd like to remind everybody that there are evaluations in your package, and my hope is that following Justice Campbell's address and before leaving today that you would be able to complete those, because the Law Society depends very much on your feedback. And without further ado, let me introduce Mr. Justice Campbell. Justice Campbell was appointed to the bench in 1998 as a member of the Ontario Superior Court of Justice, and prior to that had a very distinguished career as a litigation practitioner in commercial litigation, and particularly on his representation on behalf of doctors is very well known, and we're very grateful that he's been able to come and give us the view from the bench, if you will, on the issues that we're dealing with today. So I just asked Justice Campbell to say a few words.
Thank you. I just breached my own rule about appearing on panels, and that's not to be the last person at the end of the day. But I should tell you, in a conference call with the panel members, I asked for it because I thought it might be useful that I could sort of sum up, because in what I do, we interface not with federal panels or review tribunal, but with Ontario tribunals as well as court actions. And let me say, first of all, that the views I'm about to express in a very short period of time are mine, and you'll excuse me if they sound a little bit cynical. I do think, and I wanted to preface my remarks by saying I do accept, and because I've seen enough of it in my legal practice and as a judge, to recognize the seriousness of disability that may be classified in one way or another as fibromyalgia or chronic pain, and things of that kind. The cynicism that I have is that I don't think, with rare exceptions, our court system is the best place for resolution, at least in the first instance, of most of these kinds of claims. We see them at the trial level in 3 or 4 principal ways. Disability claims under an insurance policy, other personal injury actions in which chronic pain may be a factor, motor vehicle, as Mr. Sampliner has mentioned, and in each of those, my concern is that the adversarial nature of civil litigation has added a cost and time to claims of this kind that in many cases make them almost prohibitive. So when I sound negative, it's just as a warning to those who may be contemplating bringing court actions, that recognize what you're doing. It's going to take time. Our rules are adversarial. Our cost awards are significant, and I routinely in pretrials, settlement conferences, see cases in which the costs are such a significant proportion of the total award that makes me wonder we got to do something better. And to add to that, two other areas that are confounding in terms of trying to get a speedy and effective resolution. We are seeing more and more of claims of all personal injuries, the request for juries, particularly in Toronto. The feeling among the defense bar is that Toronto juries will be less generous in terms of award of damages than will the judiciary, particularly in the area of chronic pain, fibromyalgia. Not so out of Toronto. I think the feeling is that particularly in rural areas, that living in a community where people have to work through pain means that those peers are not, will take care of things in an appropriate way. And so it's more the plaintiff side that asks for jury, but that's not a big feature. The other reason that I get a little cynical, particularly in the motor vehicle field, is that we have had, what, 4 now or 5 regimes since 1990 that were all under the rubric of no fault. Well, if I told you that on our long trial list, of which I'm the team leader at the moment, we are getting about 80 cases a month being added to the long trial list, and that's cases that are about 15 days or more, that are motor vehicle claims. And they come to us in a complicated way, particularly when juries are involved, because there are, as you've probably heard, there are thresholds that have to be met, and the determination of whether or not a threshold is met is made by a judge. But if the threshold is met, it's up to a jury to make a determination of what the level of damages is. And what makes it complicated for practitioners who are not well versed in either the motor vehicle field or personal injury or disability law is our tests then become a tort test, which may be different than the tests that the tribunals use. And having sat enough with juries, I'm not sure that it's always easily understood by them in terms of their tests. That doesn't mean that they don't do a good job. I think they're quite capable of doing a good job. But here's the other problem that we're seeing more and more. And it was mentioned that I've spent a good part of my career defending doctors. What is a concern of mine at the moment, and a number of other judges, is that the process by which medical evidence is given in court has become very adversarial. If I go back to when I started in practice, one could expect to have a much more reasoned, neutral evaluation by a doctor or doctors that really didn't require long involved cross-examination. What we now see, and I see, are experts who are locked into a particular camp. Some of them don't believe there is such thing as chronic pain or fibromyalgia, particularly if they can't see it, if they can't touch it. If there's no direct clinical evidence, they just refuse to accept that that's the case. Whereas, as you well know, there's lots of other experts who can explain it in a much more comprehensive way. The other problem that we get in our court system is that in order to get an entitlement for damages, there is an issue of causation that may be involved, particularly for a motor vehicle claim. And typically we see the circumstance in which the physical damage to a motor vehicle, it may be very minor, but the devastation that follows to a victim is very real and it's very significant. It raises all kinds of questions, both in law and fact, as to whether that person was vulnerable to that kind of problem happening anyway, or is this something that can reasonably said to have flow from the accident. So we've got different tests when we have this in a court system, different tests for LTD from tort cases, and we have a very highly expensive adversarial system. I think one of the things that we're going to have to look at, and a lot of this comes in the motor vehicle field, and it's interesting to hear what Mr. Sampliner says, is how they can concentrate on with fewer expert reports. I get things that people want 40 experts. And we just don't have a system that can afford doing that much longer. So that kind of adds to my cynical view. The other side of it is, and that we see as judges, is I sit from time to time in our divisional court, and we have either statutory appeals or judicial reviews from other tribunals, and I must say I am very impressed with the fact-finding and often efficient nature of what goes on with the tribunals. I can understand, because we too, as some of the tribunals do, get self-represented litigants, and I can understand their frustration when they feel that they've got a legitimate claim or injury, and find that because of the test that's involved, that it's not one that's immediately compensable at the rate that they have been told that they should get. One of the problems that I see in trying to resolve the civil cases is that the bar is broken into two parts: those who really know what they're doing and are quite capable of doing a good and effective job for their clients, and those who don't understand the field at all. They don't understand the underlying statute, they don't understand the test, and they don't really think carefully of how a judge or judge and jury is likely to measure damages, and therefore implant in a client a very unrealistic expectation of what they might achieve in a piece of litigation. So when I start off with a somewhat cynical view, I can finish by saying I am impressed of how some cases can be done efficiently and can be done expeditiously, but it requires good lawyers, not just those acting for claimants or plaintiffs, but also on the other side. And we see the gamut of good lawyers acting for insured interests, and some, while they may be good lawyers, have been given very aggressive instructions. So that complicates the matter. But hope that little overview is helpful.
Thank you very much, Justice Campbell. We do have some time for questions for the panel. And I'd ask anybody here in Toronto and in our other sites if there are questions.
Yes.
Please.
I just wondered if at the in the workplace there's been a recognition of multiple chemical sensitivities and as having a physical base, not a psychogenic one.
The case law is developing with respect to multiple chemical sensitivity, and I believe the latest cases are referring to at least some psychological component to it. There have been cases that have accepted the condition and not necessarily determined whether it was psychological or physical, but just said, well, either way it occurred and we accepted, and it was related to this workplace. But I don't think the case law is saying, yes, it's always physical in every case.
If we could go then to our to our Thunder Bay site. If there's anybody there.
They've gone home.
How about to London? What's that?
London, there you are.
Are there any questions from London? Yeah, again, is there a question then from London? No. No? All right. How about to Ottawa? Any questions in Ottawa?
No questions here.
Okay, Sudbury? Any questions in Sudbury?
No questions.
Okay, thank you. Lastly, Niagara on the Lake?
Why would anybody in Niagara want to sit inside and
Okay, and any further questions, if any, from Toronto? I see somebody with their hand up. If you can come to the microphone, please.
Can people hear me?
I prefer if you could come to the microphone, it'd be better for everyone to hear you.
They can't pick you up on all those vacant seats in the other regions.
My question relates to the special confidence the WSIAT has to have in the evidence of the applicant. It struck me that that might be inconsistent with Martin to the extent that it imposes an extra burden on the...
It's going towards entitlement and whether we accept the condition, not necessarily whether we're trying to impose restrictions on this type of disability. And in fact, Martin says that that's why the Nova Scotia regime was against Section 15, because it didn't attempt to differentiate between genuine and non-genuine cases of chronic pain disability. So I don't think special confidence is against Martin. And credibility is incredibly difficult to assess, and it's going to be a combination of all of the evidence. As I said earlier, not one little piece is going to make or break credibility. It's going to be, well, if they said they didn't have pre-existing complaints and the clinical notes show a history of pre-existing complaints, so there's one thing. If they said they couldn't do various activities and the surveillance video shows otherwise, well, there's another thing. If the medical reports are saying, well, you know, there's a possible secondary gain here, there's another thing. It's a combination of things and not just one little piece of evidence that you're going to say, no, he's not credible.
Okay. Justice Campbell, do you have any comments about assessing credibility of witnesses and subjective
Well, I
complaints?
was just going to add to that. I mean, that is becoming crucial. In fact, it's put as the primary issue in most of the court cases. And when we've got juries, the defense is banking on the fact that they will be able to impair the credibility of the plaintiff and therefore diminish or destroy the ability to get any kind of an award. Yes, and we run the gamut of the use of surveillance, and I think the comments that were made earlier, I'm not sure that even with juries it often is compelling, but that is what ends up being the trial is try to turn everything into credibility and turn away from anything that might be of a more logical and scientific-based nature.
One more final question.
Ms. Martel, I was curious when you said that your policy relating to chronic pain was used as well for fibromyalgia. And with the etiology of fibromyalgia unknown, how can there be a finding that fibromyalgia resulted from a workplace injury? Or is it a case of you finding that if there's a pre-existing situation of fibromyalgia, that the workplace accident or injury has aggravated the fibromyalgia?
Well, the test is whether the workplace accident significantly contributed to fibromyalgia. So yes, there are decisions that are finding a causation between the accident and the development of fibromyalgia. And the reason why it's considered under the chronic pain disability is because it's felt that the characteristics of fibromyalgia, with the exception of tender points, and the treatment is similar to chronic pain disability. But yes, there are cases that have found a causative link between the accident and fibromyalgia.
Are there any further questions? There's one over here.
No microphone, is there?
Grab this.
Remote one.
I think there is one on there.
Yeah, very small. A question for Justice Campbell. I don't mean to add perhaps to your cynicism, but dealing with motor vehicle matters, the regime which has come into force, and we will soon be seeing cases arising from, probably some have already seen it, Bill 198, seems to put the bar further on the tort side as opposed to the accident benefit side relative to, say, Bill 59 or Bill 164 before it. I'd like your views perhaps as to what impact that may have on the courts, and also when we might expect full case management in the context of that, because there seems to be a real difference between Toronto and outlying areas as to what that's going to do.
Well, the Chief Justice has said that, I'll call it management of cases, is going to occur throughout the province. There are a couple of things that are necessary before that happens. One's a computer tracking system that can allow for that implementation. It just so happens that I've been chairing a task force looking at our discovery rules and process, and I'm hopeful, and one of the reasons for coming here today is to encourage practitioners in personal injury areas to help us when we get developing what I call best practices, because I think rather than trying to have a rule regime that mandates things in this area, the more complex cases need a time frame and a timeline that the parties work on themselves. We can't, we just don't have the judicial resources to micromanage each case, and indeed we've got to get our case management masters off that kind of process and into more fundamental management leading to trial. So there are 2 or 3 things going on, and yes, they will be necessary as the regimes change.
Are there any final questions? Allow me then, on behalf of my co-chair, Jeff Loudon, to thank all of our panelists today. Allow me also to thank each of you for attending and making this a very successful conference. We've had approximately 200 people attend, both here in Toronto and elsewhere. And allow us also to thank the Law Society for giving us the opportunity to have this forum here today. It's a very challenging area of law, a very challenging area of social policy, and I'm hopeful that each of us will have a role to play in developing this area and making it develop in a positive way that will benefit society and benefit particularly the people who are most affected by it. So thank you all very much for attending and for making this a very positive experience. If you could also, as I said, please remit your evaluation forms. The Law Society does value your contributions in that respect, and it does help in terms of formulating future programs by telling us what you appreciated about this, how you felt this could be improved, and what we can look to do in future on future occasions. So again, thank you all very much. Of some of the PowerPoint presentations which you can pick up on your way from Drs. Appleton. Okay, so please don't forget those as well.